Hi, this is Ben Freer, the owner of Freer Law. We handle immigration matters for families, small businesses, and entrepreneurs. A couple people contacted my office recently who were facing the very same dilemma. They had overstayed on their visas and they wanted to know about the possibility of staying in the United States with their US citizen spouses. Now, this is a very stressful situation. They wanted to know, would they have to leave the country? And if they did leave the country, would they be able to come back and reunite with their spouse? Now, fortunately, I was able to inform them that spouses of US citizens enjoy special privileges. And one such privilege is the ability to stay in the country, adjust status, and obtain a green card despite a visa overstay. Today, I'll briefly discuss the options that you may have if you find yourself in a similar situation. Now, typically, when a family member files a petition for you while you are in the United States, you can simultaneously file for adjustment of status and get a green card as long as you meet the requirements. One requirement involves maintaining lawful immigration status. Now, under the regulations, if you're not in lawful immigration status at the time of filing your adjustment of status, your application will be denied. Now, you're in unlawful immigration status if you've never had status. For example, you enter the United States without inspection at the border, or if your lawful status has expired. The good news is that immediate relatives of US citizens can successfully file for adjustment of status even if the authorized period of stay has expired, as long as you meet the requirements to be able to adjust status and you don't have any other immigration or criminal violations that make you inadmissible and ineligible to adjust status and obtain a green card. It's important to define the term immediate relative. Now, when I think of immediate relatives, I think of my parents, I think of my sisters, my spouse, my children. But for US immigration purposes, siblings do not count as immediate family members. So when you hear the term immediate relatives in the immigration context, know that it means spouses, unmarried children under the age of 21, and parents as long as the petitioning US citizen is 21 years of age or older. Now, in order to be able to successfully file for adjustment of status, you must not have entered the country illegally. For example, you crossed the border without talking to any US government officials. If you're in this type of situation, you may be able to get a green card, but first you'll need to seek a waiver and show that your US citizen relative would suffer extreme hardship if the waiver is not granted. This process requires you to leave the country at some point, which understandably creates a lot of anxiety. A lot of people simply don't want to leave the country if there's a possibility that they won't be allowed back in. Now, in addition to people who entered illegally, immediate relatives of green card holders who entered legally but overstayed their visa are also unable to successfully file for adjustment of status. If you're in this position, you will be required to seek a waiver if you want to pursue a green card based on the permanent resident status of your relative. So let's say that you are an immediate relative of a US citizen and you have overstayed your visa. Now, you're in a great starting position. However, there are a lot of factors that could disqualify you from being able to stay in the United States and adjust status. Most commonly, fraud and criminal convictions create problems. Now, if the US government suspects that you committed visa fraud, you'll be unable to adjust your status and obtain a green card. So how does this come up? Well, let's say you arrived on a visitor visa, then you immediately got married, and you moved in with your spouse. Now, in this type of scenario, you may be accused of fraud. The US government could say that your true intention was to stay in the United States permanently at the time that you entered. Therefore, you misrepresented your intentions and committed visa fraud when you entered as a temporary visitor. So that's one thing to watch out for. You also need to watch out for criminal issues. Convictions of certain crimes will prevent you from being able to adjust status without going through a waiver process. The regulations state that foreign nationals are inadmissible to the U.S. if they have been convicted of or admit to committing a crime involving moral turpitude, unless that crime was a purely political offense. Now, hopefully these factors don't apply to your situation. If you're married to a U.S. citizen and you overstay in your visa, please understand that there's absolutely no reason to panic. Many people who have overstayed their visas have been able to successfully file for adjustment of status. However, it is critical that you sit down with an immigration lawyer to talk about your eligibility and plan out a strategy. Now, what I discussed today was not intended to be legal advice. Please consult with a lawyer who will be able to give you specific guidance for your unique situation. Thank you very much for watching, and please let me know if you have any questions.